The wildest part is this didn't start with a lawsuit, or a screaming match, or me marching into some HOA meeting with a binder, and a vein throbbing in my forehead. It started with a man holding a tripod and a set of survey instruments, standing on the eastern edge of my family's land, calling my phone like he was about to tell me my house was on fire. "Ms. Holloway," he said, and I could hear it in his voice right away, careful, measured, the tone people use when they're trying not to spook a horse. "I'm on your eastern boundary, and I'm looking at a monument that doesn't match your deed." Now, I've spent my whole life around land the way some people grow up around church. Quiet respect, a few rules you don't break, and a deep belief that if you mess with it, it remembers. My great-grandmother bought this place in 1938. 1,100 acres in Cumberland County, Tennessee. Lake and timber, an old pasture tucked into the hills like God hid it there on purpose. A black woman buying that much land in pre-war Tennessee, you don't do that by accident. You do it because you're stubborn enough to make the world move around you. Her name was Ruth. Family said she got told no so many times she stopped hearing it. Banks, men behind counters, well-meaning folks with smiles that didn't reach their eyes. She heard the same thing, over and over. "You can't hold this, it won't last, someone will take it back." And Ruth just bought it anyway. Signed the papers, paid the taxes, kept the deed safe, and handed it down like a torch you don't drop. It went Ruth to my granddad, to my father, to me, into the Holloway Family Land Trust. Clean chain of title. 85 years of paperwork, so straight it could have been used as a ruler. I took over managing the trust in 2019, and I got into the habit of checking things the way a nurse checks vitals. Just because it looks fine doesn't mean you skip it. And in June of 2023, I finally had my little retirement project ready to go. I wanted a boat launch. Not a marina, not a money-making operation, nothing fancy. Just a simple concrete ramp on the eastern shore, wide enough for a flat-bottom fishing boat, a little gravel turnaround, a small dock so my grandkids could hop off without busting their shins. The west side had an old dock from the 1940s, still hanging on out of pure spite, but the eastern side was deeper, cleaner, and easier to reach from the county road. I'd been saying I'd do it, next year, for about 3 years straight. So I called my surveyor, David Kwan, good man, methodical, the kind who treats a weird measurement like a loose tooth. He won't stop poking it until he knows why it's there. He'd done a full boundary confirmation for me back in 2019, walked all 4 sides, found every monument, photographed everything. If David told you something didn't match, you didn't shrug it off. You listened. I was in Nashville when he called. 2 monuments, he said. What do you mean 2? There should be 1, he said, but I'm looking at 2 pins where your deed description says there's only 1. He described the first pin like he was reading scripture. Standard iron pin with a brass cap, our family surveyor's mark, set in 1967, exactly where it belonged. The second, 1 different cap, worn initials, installed with that official look like it came from a real survey crew, not a guy with a shovel and bad intentions. And it wasn't right next to the first one, either. It was west, far west. Based on weathering, David said, I'd date that second monument somewhere between 2001 and 2005. I did the math in my head before he even finished his sentence. It's a curse when you grow up around plats and boundaries. You can't not see geometry. If that second monument got used as the boundary reference, the line would jump. How much land? I asked. He paused. About 340 acres. 340. That's not a mistake. That's not somebody fat-fingered a coordinate. That's a whole chunk of my family's land, carved off like a slice of cake. I'll be there, I told him, and I drove back from Nashville on I-40 with that tight, silent focus you get when you know you're about to see something you can't unsee. When I pulled up on the eastern shore, the lake looked like it always did in June, blue-green, holding the sky in it like a mirror that doesn't lie. Sun low, light turning gold on the water. For a second, it hit me in the gut how many summers I'd stood right there as a kid, toes in the mud, listening to adults talk about land like it was family. David had flagged both monuments with bright orange tape. The 1967 pin sat where it had always sat, like a little metal witness that had survived decades without blinking. And then way off, another pin, wrong place, wrong cap, wrong story. If you start a survey from that one, David said, nodding at the newer pin, your boundary shifts. And 340 acres of your trust land becomes somebody else's parcel. Then he opened his laptop. I already checked the Register of Deeds, he said. There's a boundary survey filed in 2003. He turned the screen toward me. Developer name, Where Development LLC. Surveyor seal, Carl Hobbs. And the eastern boundary coordinates? They matched the wrong monument. I stood there staring at that screen, feeling this cold, slow anger crawl up the back of my neck, because suddenly the far shore made sense. I'd always seen those houses across the water, nice ones too. Big decks, docks, boat lifts, tidy little backyards that sloped down into the lake like a postcard. 99 luxury lakefront homes. All on the wrong side of my line. He built their houses on my land. I said out loud, not even meaning to. David hesitated like he had one more punch to throw, but didn't want to do it while you were still standing. There's more, he said. The road. Lakeshore Drive, the only access road into that whole community. David pulled up the road records and traced it with his cursor. 2.1 miles, he said. Runs from the county highway through the corridor between your boundaries before it enters the development. Then he looked at me. Based on your deed and the 1967 monument, the whole road corridor is on your trust property. I stared north along the treeline where the road disappeared. Their only road. On my land. And there's an easement, David said, recorded the same year as the survey. But, he cleared his throat, the grantor and the grantee are the same entity. Where development granted itself an easement. I blinked. He signed as both sides. David just nodded like, yeah, welcome to the part where it gets ugly. So here's what happened in plain English. A developer bought an adjacent parcel the normal way, then filed a fraudulent boundary survey that swallowed 340 acres of ours, then granted himself a road easement across land he didn't own, built 99 homes, sold them, collected tens of millions, dissolved his company, and moved to Florida like he was slipping out the back door of a restaurant without paying the check. And the whole time, families lived there. Kids rode bikes. Mortgages got paid. People grilled steaks on decks that technically sat on somebody else's dirt. It would have been almost impressive if it hadn't been my family's history he was erasing. I didn't call the HOA. I called my attorney. James Okafor, Nashville, sharp as a tack, specializes in fraud, doesn't get distracted by tears or noise. When he picked up, I said, pull everything on a 2003 boundary survey filed by Where Development in Cumberland County and a road easement from the same year. Then I told him the part that made his silence stretch. There are 99 homes, I said, and the only road to them runs 2 miles through my land. James didn't say wow or that's crazy. He said, get me the surveyor's field notes and photos. 4 days later, he called back, and the first thing he said was, your title chain is clean from April 7th, 1938 to today. That fraud didn't transfer your ownership. It created a cloud, not a conveyance. Then he said the name again, Carl Hobbs, and his voice changed. His license was revoked in 2006, James told me. Fraud-related conduct. 3 other counties. Same pattern. Moving boundary lines to benefit a developer client. So it wasn't just my family. This was a man who'd been doing this like a business model until the state finally yanked his license. 3 years too late for us. James drafted a formal notice. Polite, factual, loaded with citations. We asked for a meeting. We weren't even coming in like a wrecking ball. We said, we understand homeowners may be innocent. We're willing to find a fair resolution. Let's talk. The HOA's response? 2 paragraphs. No meeting. Just, we dispute your claims and will defend our members. And then, because apparently silence is too boring for some people, their HOA president went straight to Facebook. Deb Sinclair. Former marketing executive type. Camera ready. The kind of woman who can make herself look like the victim while holding the knife. She posted this long emotional thing about a land grab, with a photo of kids' bikes and a caption like, this is what they want to take from us. Local news picked it up. Then TikTok. Then suddenly I'm the villain in a story where my great-grandmother's deed is treated like a technicality and the fraudulent survey is treated like ancient truth. I read the comments, and I'll tell you I didn't feel smug. Those families were terrified. A lot of them had their whole life savings tied up in those houses. Their fear was real. But fear doesn't rewrite deeds. So we filed. Quiet title action. Declare the survey fraudulent. Expunge it from the record. Declare the easement void. And yes, trespass damages for the road use, because for 20 years, they'd been driving over my land on a document that never meant a thing. And that's when I realized something that still makes me shake my head. People will fight you harder for something they got through a lie than they ever will fight the person who lied to them. Deb kept posting. She kept talking about 99 families. She never once said Preston Ware. Never once said Carl Hobbs. Never once asked why a developer could collect $48 million and disappear while a community screamed at the woman holding the original deed. Then September came, and I asked James the question that changed everything. How long if they dragged this out? 18 months to 2 years, he said. Maybe longer. I looked out my kitchen window at that road corridor, like it was a vein running through my property. And I said, what does Tennessee law require for road closure notice if there's no valid easement? James paused because he knew exactly what I was thinking. 30 days written notice, he said. Certified mail to affected parties. Notify emergency services. You must maintain emergency access. So we did it by the book. 30-day notice. County emergency services notified with gate access for emergencies. And on October 16th, day 31, I drove out there with a 16-foot steel gate and 2 heavy locks, and I closed it. No yelling. No drama. Just a clean swing of steel and the final click of a padlock. 2 no trespassing signs, bright enough you could see them from the highway. Then I drove home and let the silence do what it does best. My phone started ringing. I didn't answer. Here's the part that people love to twist, so let me say it plain. I didn't go out there and sabotage anything. I didn't dig holes. I didn't break a culvert. I simply stopped maintaining a road my family didn't use, on land the HOA insisted wasn't mine, under an easement the court would eventually confirm was legally void from day one. And nature did what nature does. First big rain hit in early November. One of the culverts, one I'd been babying for years, patching, cleaning, planning to replace in 2024, failed. Water backed up, pressure built, and the road collapsed into a washout. 2 feet deep. Full width. Impassable. A couple weeks later, a second storm came through. Another washout, same story. Suddenly, even if someone cut my locks, nobody was driving that road. That's when Deb finally called me directly. Not Marge. Not friendly. Ms. Holloway, like she was trying on humility to see if it fit. The road, she said. People can't get out. I kept my voice calm. Emergency services have access. They were notified. But yes, washouts happened. You have to fix it, she said, like she was ordering a contractor. I'm not obligated to maintain a trespass, I told her. There's a difference between destroying something and declining to repair it at my expense. There was a long silence. Then she asked the first honest question she'd asked in months. What do you want? A meeting, I said, with authority to negotiate a permanent, recorded easement and a real agreement. She didn't like that answer, but it was the only one that mattered. And here comes the twist nobody in Deb's comment section saw coming, because it didn't involve a selfie video or a sad piano track. The title insurance companies got involved. 3 of them. They'd issued policies on those 99 homes, and when our lawsuit hit, homeowners started filing claims like dominoes. And title insurers, they don't run on feelings. They run on paper and liability. James called me one morning and said, they've reviewed your title chain. They've reviewed the 1967 monument. They've reviewed the surveyor's revocation. They know you're going to win. And just like that, the loudest person in the room stopped being the person driving the outcome. The insurers wanted a global resolution. Permanent access easement for the road corridor. Ground lease structure for the 340 acres the community was sitting on. Everything recorded. Everything insured. Everything clean going forward. Deb could keep posting videos. The grown-ups were at the table now. January 14th, 2024, we had the summary judgment hearing. The courtroom was packed in a way civil hearings usually aren't. Homeowners. Lawyers. Deb sitting there like she was still the face of the fight. The judge was Patricia Odom, 19 years on the bench, patient with facts, allergic to sympathy being used as a substitute for law. The HOA's attorney argued adverse possession, community necessity, equitable estoppel. Basically, we've been here 20 years, it's unfair to change it now, and you should have known. Judge Odom listened, flipped through the file in silence for a few minutes, then started talking like she was reading from the spine of the law itself. A fraudulent survey creates a cloud on title, she said. It does not transfer ownership. Adverse possession failed. Necessity failed. Estoppel failed. One by one, she knocked them down, calm as a surgeon. Then she granted summary judgment in our favor. Declared the 2003 survey fraudulent and void. Ordered it expunged from the public record. declared the road easement void from inception, confirmed the Holloway Family Land Trust as the sole owner of all 1,100 acres, same land Ruth bought in 1938. The room went quiet in that deep, heavy way it gets when everyone realizes the story they'd been telling themselves just ran into a wall of reality. And the karma didn't stop at the county line. We filed suit in Sarasota. Found the developer, Preston Ware, living in waterfront comfort like a man who thought geography was a shield. The pressure from the court order, plus the insurers coming after him for subrogation, cracked him open. He settled, sold his waterfront home, wrote checks he probably never imagined he'd have to write. $4.8 million. Not the full cost of what he'd done, not even close, but enough to make his Florida escape taste a whole lot less sweet. By April, the settlement package was signed. Permanent recorded easement for the road. Ground leases for the lots. A remediation fund to fix the washed-out culverts and restore the crossings properly, the way they should have been done in the first place. The work crews rolled in May. 2 weeks of excavation, new culverts sized right, concrete headwalls, gravel restored, banks stabilized. When they finished, that road was in better shape than it had been in 20 years. On May 20th, I drove out there and took the gate down. Not because I regretted it. Not because I'd been defeated. I took it down because its job was done. The road finally had a legitimate, recorded easement. The homes finally had documents that matched reality. And the cherry on top, the HOA held an election. Deb Sinclair, Miss 99 Families, Miss Land Grab, Miss I'll Fight to the End, got 8 votes. 8. A retired teacher named Howard Bell took the presidency in a landslide, and he called me afterward and said something I didn't even know I needed to hear. "This community owes you an apology," he said. "You offered a fair meeting in June. We should have taken it." A few weeks later, my granddaughter Zoe came to visit. 17, thinking about law school, eyes too sharp to be fooled by a pretty story. We walked the eastern shoreline in June, the lake bright again, the far shore visible through green leaves like nothing ever happened. She asked me, "Grandma, did you feel bad closing the road?" I stopped and looked out at that water, and I told her the truth. "I felt responsible," I said, "but not guilty." And that's the difference people miss. Because the lesson in all of this, the ugly one, the real one, is that the world will beg you to keep the peace when the peace benefits them, even if that peace is built on your loss. Folks will call enforcement aggression when they've gotten comfortable standing on what isn't theirs. And sometimes the only way to protect innocent people from a lie is to stop letting them live inside it. Ruth bought that land in 1938 knowing people would try to take it. The only reason it was still ours in 2023 was because she didn't fold when folding would have been easier. So yeah, 99 families got scared. A road got closed. People got mad. And a developer who thought he'd outlasted consequences had to sell his waterfront dream to pay for the damage he left behind. Justice didn't look like a movie scene with handcuffs. It looked like a judge signing an order, a fraudulent document getting stamped void, and a steel gate coming down only after the paperwork finally matched the truth. Now here's what I want to know, because this is the part people argue about in kitchens and comment sections. If you found out your whole neighborhood was built on stolen land, where does fair actually start with the families living there, or with the family that never stopped owning it? Tell me what you think. What's the right line between compassion and accountability? And have you ever watched someone use public pressure to avoid responsibility? I want to hear your story.